So I think this post from Elie Mystal says it all here. He goes, in 2 days, the SEC has gone from the primary regulator of the financial services industry to a kid whose parents bought him a fake badge to play junior detective, empowered to solve the mystery of who ate the last cookie. The SEC, which once had robust enforcement powers based on recent decisions by the right-wing Supreme Court, for their corporate benefactors who quite literally take them on $1 million trips, has gutted the powers of the SEC. There was, of course, the overturning of the 40-plus year precedent in the Chevron decision and Chevron deference. We talked about that on Friday. We'll talk more about it here. Also in the decision SEC versus Jarkizi, which was a 6-3 decision, which basically overturn the entire way that the SEC is able to have these enforcement proceedings, requiring them to have juries for civil enforcement proceedings, which they don't, which is not something they're really going to be able to do, which pretty much negates their ability to do any enforcement proceedings at all. I want to talk about these major decisions and how this billionaire class has bought their Supreme Court to do, in essence, what they want, to allow them to engage in financial fraud and to try to create an oligarchy. But I also want to talk pragmatically about what it is we can do, how we need to think about this, how we need to communicate this with others to create real awareness. And there's no one better to talk to us about this than Mike Sachs, Senior Advisor to Court Accountability, a law and politics correspondent here at the MeidasTouch Network, and with a specialty on the Supreme Court. Mike, you and I reported earlier in the week when the Jarkizi decision was handed down, which now kind of appears to be the appetizer or even the bread, if you will, of the reversal of Chevron, kind of teasing the atomic bomb they were going to drop at the end of the week by changing the kind of structure for enforcement actions in the SEC, which you and I discussed had broader implications than they were making it out to seem. But then in any way, they basically just, took their hand, if the SEC was the proverbial fly, and just squashed it. And I don't even know what the SEC is able to do anymore. So if they're even able to even function as an entity. So break it down. Why is this so significant? What does the Supreme Court do? What can we do about it?
Yeah, so the SEC can now no longer enforce civil penalties and bring civil penalty enforcement actions to its own in-house judges. And that's actually a pretty huge thing, because until this week, the SEC was able, under the Dodd-Frank Act, to bring before its administrative law judges people who had committed securities fraud and say, hey, this guy needs to be held accountable and slapped with a bunch of fines. And the administrative law judge would say yes or no, and they'd go through the process, and whoever was brought through could appeal to a federal court and say they got it wrong. And that was not only huge for efficiency's sake, but also was consistent with about 170 years worth of precedent of the United States courts. But this past week, the Supreme Court said, we don't care. No. Because if you try to bring any enforcement action, it can't go through the agency, which is charged with protecting this public right of the security of our financial markets. Or rather, it has to go through a jury trial. Now, that sounds like it makes sense, right? If the government comes after you, then you should be able to get a jury trial. But for 170 years, there has been a distinction between when you can go to get a jury trial, and that was always that choice to do so in these cases, or whether you go through the executive's in-house adjudication process. For 170 years, that was seen as okay, because you're vindicating a public right, a right of the people to have our financial markets not be distorted by fraud. But this week, the Supreme Court let it out of existence. And in doing so, in what seems like this common sense thing, which actually was not consistent with precedent for 170 years, the Supreme Court was actually serving the interests of the right-wing dark money web, the Koch brothers and Leonard Leo, the people that helped put this majority into power in the Supreme Court, serving their interests by knowing that this decision would virtually end the SEC and about 24 other similarly structured agencies' ability to enforce their rules. Because these agencies don't have the resources to go to federal court every single time to enforce their actions, to enforce these rules. They just don't. And that's what's under the hood. That's what's between the lines of this decision, is this understanding, this knowledge. And that's particularly and exactly why Jarchese himself, who is a right-wing radio host as well as a bad-acting hedge fund manager, according to court papers, and is being slapped with civil penalties for being fraudulent. They know that this wasn't just really to vindicate Seventh Amendment rights. This wasn't about that. By the way, the Supreme Court doesn't really care about the Seventh Amendment rights of consumers when they are built by big corporations and then forced into arbitration as opposed to going to federal court to vindicate their actions as a class when they get built through contracts of adhesion where they were forced to go to arbitration even though they didn't see that in the very fine print of their contracts for their cell phone bills. Nope, forget those people. They don't get a jury trial. But people who are security fraudsters, booking investors and the public out of millions of dollars, well, they get the jury trial against 170 years of precedent because those they represent, the ideological movement they represent, want to make sure that the SEC cannot regulate and cannot ensure fairer markets for the American public. That's not what they want. They want more and more profits. And this court served those interests this week.
Yeah, and so it's not saying that you can't have juries in criminal cases. Of course, you can have juries in a criminal case. This is the ability of agencies to engage in civil enforcement actions against bad actors. And in this case, the bad actor said, you know what? I should be entitled to a jury, which was part of the civil enforcement proceeding. Not that I didn't do it. I need a jury. And ultimately, the SEC was like, that's just not what we have in our civil enforcement proceedings. We have administrative judges who are then reviewed by a federal judiciary on an appeal process. So it's not like there's no accountability. It's not like the SEC just makes these decisions and there's no accountability to reverse a bad decision. A federal judge would actually be able to review the outcome of these civil enforcement actions. But now the SEC is unable to have these civil enforcement actions because it doesn't have the infrastructure to do it. So you had that, and then you have the decision later in the week on Friday overturning Chevron, where the SEC and all agencies now are not given any deference to enforce any of its enabling statutes or to engage in any of the proceedings or procedures that it normally would. And courts in this massive power grab said, it's not up to you anymore, SEC or EPA or any agency, but specifically as it relates to the SEC, I think it's going to have major ramifications there as well with how it enforces its regulations to stop bad actors engaging in securities fraud or other things. If the courts can step in and say, no, you're that's not how you should be doing it. You don't have any right to interpret your statutes like that. You think Chevron's going to impact the SEC that way as well?
It'll impact every agency that regulates in matters where the Congress hasn't fully foreseen, but is with reason has reasonably regulated in those areas under the statute that brought those agencies into being. So as you were talking, we need to make clear, this isn't just a court's power grab from the agencies and from the executive branch. It's a power grab also from Congress. Because Congress passed the law enabling the administrative law judges to enforce adjudicate civil penalty enforcement actions under the SEC and about 24 other agencies. Congress did that, acting in the understanding of past precedent, allowing those things since the 1850s. And then the Chevron case, Congress has for 40 years been able to step in and say, no, the court got it wrong in 1984 when they said that courts should give deference to regulators when interpreting a statute that doesn't clearly speak to this particular thing. For 40 years, Congress had the power to say, no, we actually think that courts should have the power to do that, and regulators should not be deferred to. And for 40 years, Congress has done nothing and passed law after law after law dependent on both that 1850s statute saying that that in-house agency adjudication is permissible without violating the Seventh Amendment, and that regulators can pass laws, can effectuate rules to regulate or deregulate when Congress, when it's a reasonable construction of Congress's statute saying they could do one or the other. Right? This is about Congress. This is about the court acting supremely. It's about judicial supremacy, juristocracy, ruled by judges over both branches that are responsive to we the people. At least for now, because the court's also been working very hard to even make sure that those branches cease to be responsive to we the people as well.
So what do we the people do? I mean, you and I went to law school together 15 years ago or so. Our textbooks may as well be flushed down the toilet bowl or thrown into the dumpster, whatever you name it. Look, you're senior advisor at Court Accountability, and we're not just descriptive. And what you do, you're prescriptive as well. So, I don't just want to be doom and gloom, but let's face it, there was a 40-year, 50-year methodical project implemented with precision by right-wing oligarchical groups that wanted this. And they came in and they got what they wanted. And so what is there to do, though? I mean, how do we give people their, no pun intended, because we're talking about agencies, how do we give humans, how do we give Americans their agency in themselves and their power back?
Yeah, well, let's remind our viewers that those right-wing interests are real people who gave real money, in fact, $4 million such money, in gifts to Justice Clarence Thomas over the past several decades that he has not reported until reporting found out otherwise. And then he's been disclosing piecemeal whenever he's caught on his annual disclosure forms. That's not a good state of affairs. These justices are, under federal law, required to recuse when there's an appearance of bias in their cases. And yet they haven't recused in key cases in which these parties that give them lots of money to live a higher life than they otherwise would on their judicial salary come before the justices, or similar interests come before the justices, because these same people that help get these justices on the court, these same dark money interests, are also funding the litigation that's going up to the Supreme Court for them to make these decisions. So we the people can start through our Congress. And I've said I'm a senior advisor at Court Accountability, and Court Accountability has been quite vocal about congressional investigations into Justice Thomas's receipt of millions of dollars of gifts, into Justice Alito's flying an upside-down flag and a Christian nationalist flag at his property that he's blamed on his wife, and so be it. But spousal conflicts of interest are also part of the federal law that requires recusal that these justices are not abiding by. We can get Congress to pass laws that are currently introduced to enforce ethics, to create an inspector general for ethics within the judiciary, to pass a gift ban so that the Supreme Court can't accept gifts more than $50 in value, which is what is the rule for the members of Congress. These things are there. These laws are there. They just need to be passed. So what can we the people do? We the people can encourage our Congress to push forward with these things. We the people can be aware of what's going on with the Supreme Court and understand that the Supreme Court itself is the main policy-making and breaking body in this country, and they can be responsive to politics, either through its composition or through pressure. And to see our government not just as what the president does or what Congress does whenever they do anything, but also that this Supreme Court is a political actor, and that we should understand this: the Supreme Court will not save us from ourselves, will not save us and our democracy. It's on us. It's on we the people to get our Congress to rein the Supreme Court in and exert its own co-equal ability, the first mentioned branch of government in our Constitution, to regulate the court, despite what Justice Alito told the Wall Street Journal last year, that the court can't be regulated by Congress. He's wrong. And to then assess our government accordingly and exercise the power that we have as the people to make sure that our democracy doesn't die with this court and those it enables.
There you have it. Mike Sachs, Court Accountability Senior Advisor, a correspondent here on the Midas Touch Network, Law and Politics, and of course, all things Supreme Court. Thanks for joining us, and really appreciate these deep dives and just kind of breaking it down for everybody to understand. Hit subscribe. Let's get to 3 million subscribers together. And thanks everybody for watching.
Real quick, Meta just changed their algorithm to suppress political content. Please follow our Instagram at MidasTouch right now as we head towards 400,000 followers so you don't miss a beat.